First District Court of Appeal is now in session. All who have business before this court, draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Welcome to the First District Court of Appeal. We have one case on the docket this morning. It is 22-1588 Jordan Anderson and Lindsay Hall versus School Board of Escambia County. You may proceed when ready, counsel.
Thank you, and good morning, Your Honors. May it please the Court. I'd like to reserve 5 minutes for rebuttal. My name is Dwight Slater, and I represent the parents and personal representatives of Audie Anderson, the appellants in this case. Your Honors, the central question here is whether the school board received timely notice.
Please bring the mic just a little closer to you.
Sure. Is that better?
Yes.
Thank you. The central question here is whether the school board received timely notice from the parents in this case. And I submit to you that under any reasonable view of the law and the facts, that's exactly what happened here. The law requires this court to strictly construe the waiver of sovereign immunity statute. The strictest construction...
Counsel, I'm sorry, let me stop you real quick. Are you saying then that, excuse me, the plaintiffs were in fact required to notify the school board?
I'll get there, Your Honor, if you allow me just one moment. We believe that the strictest construction of the statute says that notice is required to both the school board and to DFS within 3 years. That is except in the case of a wrongful death action, which we have here, in which, in that case, notice is only required to DFS within 2 years. And there's no dispute here that the parents did, in fact, provide notice to DFS within 2 years. Audie died in September 2017. Notice to DFS was sent January the next year, well within the time frame.
So you think the sub 2 that says that for wrongful death that notice must be made to the Department of Financial Services, do you think that totally obviates the need to notify the actual agency that's being sued?
I think so. Under the plain reading of the statute, that's what it says. If the court notes that prior to 2011, the statute said only DFS and the appropriate agency within 3 years. In 2011, it was amended to accept the cases of wrongful death, in which case it's only to DFS within 2 years. So it's our view that that's what the strictest reading of the statute says.
Counsel, do you think it matters that if you look at 6A1, subsection 1, not applicable in this case, but that it says except that, and then 1 and 2, 2 is 1 here. Without reading the entire thing, it is an alteration of the time that is required. And that's pretty much all it is. For a certain type of case, it alters the time frame. So isn't that relevant to say that the purpose of subsection 2 is to alter the time frame and not to alter who needs to be notified?
That's one reading, Your Honor. Again, I submit that that's not the strictest reading. It says 2 years to DFS. But to take that point to the next level, the next strictest reading is notify the appropriate agency within 3 years and DFS within 2. That's what it says.
Does that make sense? Is that logical?
I don't think it makes sense. I think it makes sense the reading that we are proposing. But of course,
It's pre-suit notice.
It's pre-suit notice.
So 3 years would have been after when the suit was filed.
True, but and this is not entirely relevant here, but there's case law that suggests that the notice is timely as long as it's served, even after the suit is filed, as long as it's served within the statute of limitations. Here, the statute of limitations is 2 years, so 3 years would be outside of that. But again, that's the second most strict interpretation of the statute, and that's what the court actually applies the least, I think, strict interpretation, which is to say that that 2-year exception modifies both who you need to notify and the time limits. That's what the court said, and that's what DFS is arguing. And I would submit that even in that case, the parents did provide timely notice to both the department and to DFS. First, the timely notice came accepting right now the numerous communications between Attorney Upton and Mr. Baker that occurred in the immediate aftermath of the incident. The parents' attorneys actually did send notice to the the school board in October 2019. which is still within the 2-year time limit because the statute of limitations was told for a period of 90 days while the first notice to DFS was being considered, and that's by operation of law. So even if we accept that the notice has to be sent to the school board and to DFS within 2 years, it was because the statute of limitations was extended for an extra 90 days. So the October 2019 notice was sufficient. Now, if the court doesn't accept that, then our position is the numerous communications between Mr. Upton and Mr. Baker qualified as sufficient notice. Now, the only requirement for the notice is that it be written, and certainly the numerous emails between Mr. Baker and Mr. Upton were written. The only other requirements are that it provides sufficient information to the appropriate agency and to DFS to be able to evaluate the claim and to put them on notice of a demand. And I submit to you that those communications did just that. In these letters, they're talking about coverage issues. They're talking about having a settlement discussion. There's no question that the incident was clearly identified. I don't think anyone is taking the position that the school board didn't know.
Counsel, do you have to be a lawyer to send that notice?
I don't think so, Your Honor. And in my reply brief, I detailed all the reasons why. You certainly don't, because a parent could send the notice. Anyone off the street could send the notice. There's no requirement that.
Yeah, but a parent can represent themselves.
Sure, but it just says notice, Your Honor.
A non-lawyer can't represent another person.
That's fair. But it just says notice. It doesn't, in my view, the notice at this stage or that stage of proceeding is not tantamount to filing something in court. And I believe Mr. Baker would be right.
But you make the argument that Mr. Upton's first letter satisfied the requirements of the notice provision, and it contemplates preserving evidence and sitting down and trying to settle the case. Isn't that the practice of law?
I would say no. In terms of whether notice is provided, I don't think that's the practice of law. So, as I stated in my reply brief, Mr. Upton is representing Louisiana clients. They live in Louisiana. He's a Louisiana lawyer. So I don't think it's improper in those circumstances to have those discussions with Mr. Baker. Now, when it reaches the point where he has to file a lawsuit, that certainly you need to have a Florida licensed lawyer, and that's what happened here. Mr. Monroe took over the case, and he filed the appropriate notices and he filed the lawsuit. As I was saying, the notice only has to be in writing, and this court and others have held that it needs to sufficiently describe the occurrence, which I believe it did. All of the emails together, or any of them separately, did. Has to put the agencies and the department on reasonable notice of the existence of a claim and a demand. So,
does it have to notify the government agency of the threat of a lawsuit or a pending lawsuit coming as a result of the claim?
Your Honor, I don't think it's that specific. I think, as we said, it has to just provide notice of a claim and a demand. So whether that means a threat of a lawsuit is one way to read it, or otherwise it could just be, look, we believe that the school board is responsible for our damages, and we'd like to discuss settling it. I think in those circumstances, those facts would be sufficient. So no, I don't believe there's any magic language, but if that were a requirement, I think the letters certainly suggest that a lawsuit is pending. Mr. Upton is talking in his letters about hiring a Florida lawyer if we need to. We'll go ahead and engage a Florida lawyer if we're going to file a lawsuit. So if that is a requirement, I think it was met here. Beyond that, if the numerous communications between Mr. Baker and Mr. Upton do not qualify in the court's view as sufficient notice, we believe that the facts here establish that the school board actually waived the notice requirement through their actions. I cite in my briefs the case of Rabinovitz versus the town of Bay Harbor Islands. In that case, the court held that in instances where the officials acquire actual knowledge of the incident, pursue an investigation that reveals essentially the same information as the written notice would provide, and then thereafter embark on a course that reasonably leads the claimant to believe that formal notice is unnecessary. We believe that's what happened here. All the communications between Mr. Upton and the school board prompted an investigation. They assigned the term is escaping me right now. They assigned their risk management. They opened a file in risk management, which only happens if you're going to investigate a claim. They assigned an attorney that specifically handles tort claims. They didn't use their in-house counsel. They assigned Mr. Baker, who handles exclusively the tort claims for the school board. And then they discussed settlement, and they took all of these steps, preserving evidence, viewing evidence. All of these things are the types of things that would happen if the school board were to embark on its own investigation. And then beyond that, Mr. Upton testified and provided an affidavit that he was under the impression that no further notice was required. And that's his statement was that he was advised that no further notice was required of him.
Now,
So-
Mr. Slater, I want to confirm, I'm going through the trial court's order dismissing count one, granting summary judgment on count one, and it acknowledged this alternative argument that, plaintiff argues essentially, waiver of the notice requirement or estoppel, but then it never addresses that argument. Did it ever make any explicit ruling on this argument or delve into it?
No, the court did not make an explicit ruling on this argument, as I recall. I do believe it's implicit in this order that it didn't accept that argument. So to answer your question, no, it was not explicitly ruled on. Actually, let me take a step back. I might want to revisit that because I believe there was a motion for rehearing after the first order. If it pleases the court, I'd like the opportunity to supplement my response after, if that's okay, because it's actually escaping me right now. I apologize for that. Now, I'd like to briefly address count two. We also believe it was error for the court to dismiss count two at this stage of the proceedings. The law permits parties to plead in the alternative, and that's what the parents and the personal representative did in this case. I understand the trial court's point on this, but I believe it's a case by this court that held that, or in the particular case that I cited, had no problem with the plaintiff relying on the same set of facts for both the wrongful death claim and the survivor's claim. And I believe that's okay here as well. And the reasoning I would submit is that the school board denied liability for causing the death. So that is in dispute here. And more than that, they suggested in their affirmative defenses that a third party could possibly be responsible. So if that's the case, we should be allowed to plead in the alternative. Now, it could be that the choking incident resulted in a death. I don't think it can be said at this stage that that's 100% the case. Audie survived for a couple of days in the hospital. So those days in the hospital, I think, are damages. He has medical bills. That's in the record. Those are the types of things that we could pursue in a survivor's action. Now, if it turns out that the death was caused by the choking incident, then perhaps the court's ruling would stand. But at this point in the proceedings, I don't think it is appropriate, especially because we weren't allowed to actually explore the claim. As I mentioned in my briefs, the court limited discovery to strictly the notice issue. And by the time we got to count two, the court, my clients filed a motion to reopen discovery to explore some of these options, but the court never ruled on that and instead granted summary judgment with that outstanding discovery in place. So we also believe that was error as well. So I see I've got a couple minutes left before my rebuttal time goes, but I'll just say, in short, we believe that the strictest interpretation of the statute is one that requires notice only to DFS. The second strictest requires notice to DFS within 2 years, school board within 3 years, even though that doesn't necessarily make sense. Beyond that, we do believe that notice was provided in the form of numerous communications between Mr. Upton and Mr. Baker. And if that's not enough, it was the notice requirement was waived by the department, the school board. I'd like to reserve the balance of my time for rebuttal. Thank you.
Not quite as tall as Mr. Slater. May it please the court, my name is Steve Baker, and I have the pleasure of representing the Escambia County School Board.
So, Mr. Baker, Mr. Upton sent the letter to the school board, advised them that he was representing Ms. Hall in this case, And there was a bunch of stuff about preserving records, and there was some talk about talking, and you got assigned to the case.
Well, it was a very limited assignment, and I do want to address that.
And you're the tort lawyer. So someone said we might be facing a lawsuit here.
No, Mr. Upton had written a letter to the principal, and that's part of the record, saying, I'm coming tomorrow to the school, and I want to view the video, and you have to preserve the evidence. We have that happen occasionally from time to time where people contact the school principals, and I was retained for one simple task in this case, and that was to contact Mr. Upton, tell him he's not to visit the school, that he's to communicate with me, and he can come to my office and view the video. And if you look at the record, you see a lot of things where Mr. Upton is talking, but what you don't see and what you cannot see, or doesn't exist, is me responding to those emails, other than to say, if you want to come to my office and view the video, you can do that. Because that's all I was tasked to do at this point. I was not tasked to investigate the case. You know, it's the school board. We're not, I mean, they understand. I mean, the child died. Was there the possibility? Of course there was the possibility. But quite frankly, after having reviewed the video myself, I didn't see that there was any possibility that anybody was going to file a lawsuit, because in my view, everything was done very appropriately. So, no, I was not hired. I was hired because I was a tort lawyer, but it was on a very limited assignment. I was not hired to negotiate and didn't negotiate.
So, but when you got the email from Mr. Upton that said, hey, I'd like to sit down and talk to you about this case, I want to avoid litigation, I don't want to file a suit, we think we can reach settlement, wasn't that notice that they were contemplating suing?
I think it was in that very same email, he said, I have reached a preliminary decision, or I've come to a preliminary decision. That does not mean that he's made a decision, and you can't morph I'm thinking about it into this is a notice of a claim, and there's no, that's just not it. And
isn't the whole purpose of this notice of claim statute to cause this conversation to start before anybody files a lawsuit, and to obviate the filing of a lawsuit in many cases?
It's not a conversation. It's not to start a conversation. It's to start an investigation by the appropriate agency. And once that is complete, then to start the negotiation.
Well, I'm sorry, how is the plaintiff supposed to direct that? If they provide notice to the school board and say, I'm interested in suing, does it matter to the plaintiff whether the school board actually conducts an investigation?
It does under this statute.
So if I give a notice and say, this is notice under 76828 sub 6, that I intend to sue, and you conduct no investigation at all, then that doesn't count as notice. I can't sue, I can't file a suit because there's been no valid notice.
If you send in a notice that says, we are making a claim, and this is how we value the case, because that's what the case law says. You have to send notice that says, there's no form required, but two things have to be in there. I'm making a claim, and this is how I value the case. This is my demand. I have to give you a dollar figure. Neither one of those things happen. But no, if 6 months goes by, or in the case of wrongful death, 90 days goes by, then the plaintiff, after having given a valid notice, is entitled to file suit.
I'm not seeing anything in the statute that says that the claimant is required to provide a dollar figure before the notice is valid.
It's not in the statute, it's in the case law that says you have to give a note, say, I'm making a claim, not I'm contemplating, we'd like to investigate that because
How is that requirement not contrary to the statute?
that you have to put a dollar figure in there?
Yes.
Because it's the case law.
Well, that doesn't answer my question.
It-
I'm asking you, how is that not contrary to the statute, to have that requirement?
Because the statute says you have to give a notice of claim, and the courts have construed what that notice has to entail. There's no real detail in the statute as to what has to happen. But the courts have said, and this court has said, in order for it to be a valid claim, you have to say, this is a claim, and this is what these are the facts of the claim, and make a demand.
Now, cases from this court also have contemplated that an agency can waive the notice requirement. And looking through the record here, it appears there was an affidavit for Mr. Upton and his deposition testimony where he indicated that Mr. Baker advised further written notice was not expected or needed. That's from page 177 of the record, the Upton affidavit. Also, in the deposition at page 143 of the record, Mr. Upton testified, but it did not require, according to him, Mr. Baker, any further paper notice to be sent. We were past that. Why isn't that enough to create a genuine factual dispute on this waiver issue?
A host of reasons. Number one, I have no authority. I am a contract worker. I have no authority to bind the school board in anything, number one. Number two, when I told Mr. Upton that he didn't have to do anything else, it was in reference to getting to view the video, not in reference to anything.
But aren't these all factual questions that would be enough to overrule?
That little tidbit may, but the bottom line is, I was on a limited assignment to let him view the video, and his communication with me went on for less than a month. So there is no way that I had any authority to waive.
Is there anything in the record indicating that you had limited authority? Is there any correspondence where you expressly said, I have limited authority?
The fact that I never responded to any of his emails saying, let's sit down and have coffee and settle this. I don't have I didn't respond to that. I have no authority to respond to that.
But you did have face-to-face meetings and phone conversations that weren't documented. So, he's alleging that in your conversation, so it wouldn't have been written down.
Well, does it do any good for me to write somebody that says that and say, I don't have the authority? I can't settle with you. I had no authority to do that, and as a contract worker, not an employee of the school board, I have no authority under any circumstances, even in the cases that where litigation is going on. I cannot bind the school board.
Well, even if I accept that you didn't have the authority to waive a requirement for the school board, my understanding of estoppel is that the issue is whether the plaintiffs were somehow prevented from doing something based on the apparent authority of someone, which is, my understanding of the appellant's claim is that maybe there was apparent authority that caused them to not file a notice of claim.
Well, if that was true, why did he give why would he give notice to the Department of Financial Services if I could waive the requirement of giving notice? And there is nothing that I did that even hinted at apparent authority or caused them to think that I had the authority. I let him into, I got a hold of the video of the incident. I had him into my office to view the video, and I never responded to any of his invitations to try to negotiate. That cannot be considered as me giving apparent authority. You know, the fact that I allowed him to view the video and told him not to go to the school. I don't know, you know.
But you started performing an investigation, correct?
Me?
Yeah.
No.
You watched the video, didn't you?
If watching a video with somebody that requested to get the video, if that's considered an investigation, I did an investigation. But no, I did not do an investigation. I can tell you that when I am given a case.
So you didn't talk to any of the other employees about the response or anything like that?
No. I talked to the principal to get the video and get some idea of, you know, what are we talking about here, so that I, you know, knew that I had the correct stuff. But in cases where we have a notice of claim and I am tasked to do an investigation, I go out and take statements, I get all of the records, I get everything. None of that happened in this case, because he had written this letter, you know, and it's one of those letters that we get from some, and I have to tell you that 99 and 44 100% of my practice is a plaintiff's practice, but I abhor these lawyers that write letters to the school, to the principal, and start making demands, because I think that that's just not the way to practice law. And it causes a lot of angst with the principal. He should be communicating with the school system, not with the principal. And then saying, I'm going to be there tomorrow, that's, again, not the way to do things. And so, again, I was tasked to stop him from going to the school board and perhaps creating an incident. And if you read any of his emails and correspondence, you notice that it's all about getting publicity and claiming that CNN is involved, Oprah's involved, and the Ellen Show is calling him. It's an unfortunate thing that we can today have to contend with that in the practice of law. And I hearken back to when we started, when we were told that if we start advertising, it's all going to be very dignified and professional, and we all know where that is today, and that's something that, you know, after practicing law for 47 years,
So why wasn't the October 22nd, 2019 notice of claim by Mr. Monroe effective?
Because it was a year and a month, it was 2 years and a month after the incident.
Sub 2 of 768-286A sub 2 says, if the action is wrongful death, the claimant must present the claim in writing to the Department of Financial Services within 2 years after the claim. So that was satisfied, correct?
I'm assuming
claim
so,
was,
I've never
DFS received notice of claim within 2 years, correct?
DFS did,
Okay.
assuming that his
So if you
affidavit
look
is
up here, there's a 3-year notice of claim requirement to the agency. Is that incorrect?
For a wrongful death claim, it is, because the statute of limitations runs after 2 years. But there was no extension of
An action may not be authorized on a claim against the state or one of its agencies, that's the school board or subdivisions, unless the claimant presents the claim in writing to the appropriate agency and also accepts as to any claim to a municipality, county, or the Florida Space Authority, so that's not the school board. Present such a claim in writing to the Department of Financial Services within 3 years, and to the agency.
Because for a wrongful death.
And later on, it modifies that time frame for DFS, but it doesn't say anything about the time frame to the agency that it's affected.
Well, the reason is because you've got to give notice to the appropriate agency within the time frame so that the investigation can be done before your statute of limitations expires. And the statute of limitations for a wrongful death is 2 years. So that's why you've got to give notice.
And also it was filed post-suit.
I'm sorry?
And also the notice of claim was post-suit.
Correct.
Is that one of your arguments? Okay.
Correct. And if you read the statute and you were to think that you have to give notice to the appropriate agency on every claim except a wrongful death claim, I would suggest that the prudent lawyer would go, I think I need to read that again, and maybe I need to read some case law. Because what that would say is that in every case that a student sprains an arm or a finger or breaks a finger, the school board would have to be given notice of that claim so that they could do an investigation. But in the case where there is a death, you don't have to give them notice. And that would be the most serious claim that could be made against any governmental entity other than perhaps paralysis or quadriplegia. Those would be.
But in the argument against that, if somebody sprained their ankle, the school board may not know about it, but if someone dies on their premises, certainly they know about it.
You still have the opportunity to do the investigation into the claim.
Yeah, but you know about it. I would think anytime there's a death on the premises of the school board, there's an investigation, even if there's not a notice of claim, correct?
Maybe, maybe not. In this case, I don't know how much of an investigation. We've had some cases where we've had children attacked, and there's a big investigation. In this case, if you review the video, maybe you do, maybe you don't, because you review the video and you see that everybody did everything right. But to think that the statute would not require notice if you're going to sue for the most significant injury that could occur on a school campus, when the purpose of that is to give the school or give any governmental agency notice that you're going, and have the opportunity to investigate. You might want to think about that if that's the conclusion that you came to. And the other thing that I think you need to do is to realize what the purpose of DFS. And if you look at the 768.28 parentheses 3, you see that the Department of Financial Services can be contacted by these agencies to assist in the consideration of the negotiation of any settlement and the conclusion of the settlement. I'm sure that there are a lot of smaller agencies that don't have risk managers and that sort of thing, and that's why you give notice to DFS, is that they are there to assist in the resolution of these claims if necessary. This is a tough case because it does involve a death, but it also points out why I didn't and why we should not respond to out-of-state lawyers who are not licensed in the state of Florida and should prevent them from trying to practice law in Florida without the assistance of a lawyer. It's unfortunate that Mr. Monroe did not consider the decisional law of the state with respect to this statute, but unfortunately he didn't, and that's where we are. And the decision of the trial judge should be upheld.
Thank you, Mr. Baker. Mr. Slater?
Thank you, Your Honors, and I'll be brief. First, I'd like to point out that I believe Mr. Baker just conceded one of the main points in this case, and that relates to waiver. Judge Nordby, you asked whether it matters that there's a factual dispute on the waiver issue, and I submit that it does, and the case law is clear on that. Mr. Baker said it's just a little matter, but there is a factual dispute whether the notice requirement was waived here. So on that basis alone, this court should reverse the final judgment.
Well, on that matter, I thought Mr. Baker raised an interesting issue, which is that if the school board waived notice, I'm sorry, if your client was stopped from filing notice, why did it file notice?
I don't believe that my client wasn't stopped from filing a notice, but
So it is strictly waiver. So if he didn't have the authority to waive, then there is no waiver.
No, the argument is that the government should be stopped from claiming lack of notice because they waived the requirement by their actions in engaging in all these discussions and opening an investigation. And there is a dispute there. Mr. Baker just said that he viewed the video and found that there was no liability. That in and of itself is an investigation. Now, sending, I want to say CYA, but I realize that's inappropriate, but sending a cover notice after the fact to make sure you're perfecting your claim, I don't think necessarily negates the arguments that notice was already required. But perhaps anticipating something like this, my clients decided that it was probably the best practice to go ahead and file that second notice. But I don't think it was required here because notice was given. So in short, I believe that Mr. Baker conceded that there's a factual dispute with respect to waiver. On the issue of authority, Mr. Baker says that there was no apparent authority. I disagree, and I think the record establishes that. Mr. Baker told Mr. Upton that he should direct all his inquiries to him, wasn't to speak to anyone else. So if he's not allowed to talk to anyone else, that to me suggests that he has the authority to engage in all of these discussions. Remaining silent in the face of these issues does not suggest to anyone that authority isn't there. In fact, the most it suggests is that he's ignoring you. So I believe that the authority was apparent because he was the only person that Mr. Upton was permitted to speak with. Lastly, and Judge Roberts, I think you made the point. This is not a simple case where someone trips on a manhole or something where the department or the appropriate agency may not have an idea that there's a claim out there. But a child died in a school, and it was all over the news, and everyone's talking about it. We know there was an investigation done, and we know that there was a claim made, and we know that they had notice about it. The statute says what it says. It says notice to the department, to DFS within 2 years. That was done. Whether that makes sense or not, I submit is more an issue for the legislature. If they want notice to be given to both the appropriate agency and to DFS, they should say that. They didn't say it here. The trial court inserted what it thought it should say, and the case law is clear. You're not allowed to do that. Mr. Baker's right. This is a tough case. Factually. Legally, I don't think it is, because the sole question is whether the school board received notice, and we submit that it did in several ways. And if there's nothing from the court, we'd like to rest on our briefs and ask that the court reverse the final judgment. Thank you.
Thank you both for your argument. We have no other cases scheduled for this morning, so we are adjourned.
All rise.